Hi, my name is Sharif Rubin. Today I'm going to be discussing obscenity and indecency. Obscenity deals with patently offensive, sexually explicit speech or material. If found obscene by the U.S. Supreme Court, then it loses protection under the First Amendment. The Miller versus California set the standard for obscenity and what is patently offensive in the United States, and this was in 1973. Some background on that case. A man named Marvin Miller was convicted of using mass mailings to sell his book, Sex Orgies Illustrated. It contained pictures depicting men and women in groups engaging in a number of sexual activities. Some brochures were mailed to a restaurant, and the owner complained to the police. The U.S. Supreme Court held that patently offensive material refers to patently offensive representations or descriptions of ultimate sexual acts, normal or perverted, actual or simulated, and patently offensive representations or descriptions of masturbation, excretory functions, and lewd exhibition of the genitals. Patently offensive also refers to any obscene acts or materials that are considered to be openly, plainly, or clearly visible as offensive to the viewing public. According to North Carolina General Statute, Chapter 14, Section 190.1, subsection C, for purposes of this article, any material is obscene if the material depicts or describes in a patently offensive way sexual conduct specifically defined by subsection C of this section, and the average person applying contemporary community standards relating to the depiction or description of sexual matters will find that the material taken as a whole appeals to the prurient interest in sex, and the material lacks serious literary, artistic, political, or scientific value, and the material as used is not protected or privileged under the Constitution of the United States or the Constitution of North Carolina. As used in this article, sexual conduct means vaginal, anal, or oral intercourse, whether actual or simulated, normal or perverted, or masturbation, excretory functions, or lewd exhibition of uncovered genitals, or an act or condition that depicts torture, physical restraint by being fettered or bound, or flagellation of or by a nude person or a person clad in undergarments or in a revealing or bizarre costume. Indecent material has limited First Amendment protection content that is not as graphic or as offensive. The goal of indecency laws is to protect children from getting access to sexually explicit material while allowing access to adults. In the 1978 case, the FCC versus Pacifica set the standard for the country. A little background on that court case, John Douglas heard a radio broadcast of George Carlin's routine, Filthy Words, which is 7 words you can't say on the TV, with his child in the car over WBAI, which is a Pacifica Foundation FM radio station in New York City. He complained to the FCC. That eventually led to the court case. The Supreme Court ruled that the FCC had the legal authority to regulate indecent speech over the public airways. They wanted to hold the government's interest in shielding children from the potentially offensive material and ensuring that unwanted speech does not enter one's home. And according to U.S. Supreme Court Justice John Paul Stevens, patently offensive, indecent material presented over the airways confronts the citizen not only in public but also in the privacy of the home, where the individual's right to be left alone plainly outweighs the First Amendment rights of an intruder. Thank you for watching. This is what I have learned in my mass communication media law class over the past few weeks. And have a great day.